This installment of the Crucible examines the risk management strategy of apologizing for medical errors. And the paper is a published legal opinion. It comes from the Ohio Appellate Reporter in 2011, and the case is Davis v. Wooster Orthopaedics. And as I've said in the past, a published opinion in the legal world is the equivalent of a published study in the medical world. The case involved a patient named Barbara Davis, who was 49 years old. She underwent elective back surgery and died shortly thereafter. Her husband filed a lawsuit against Dr. Napick, who was the surgeon. The lawsuit alleged that Dr. Napick negligently severed the common iliac artery and that this caused Mrs. Davis's death. At trial, the patient's husband and daughter testified that after the surgery, Dr. Napick told them that he had nicked an artery and that he took full responsibility for doing so. It appears that Dr. Napick also told the family he was sorry. However, due to Ohio's apology law, this evidence was excluded and the jury did not hear any testimony about Dr. Napick saying he was sorry. The jury found Dr. Napick liable for malpractice and awarded the family $3 million. This case demonstrates a number of interesting points about the apology approach. And for those of you who are unfamiliar, over the past 10 years, the medical legal community has embraced this idea that when we make a mistake, the best strategy is to just tell the patient what happened, take responsibility, and apologize. And this approach allegedly produces a number of medical legal benefits. First, it reduces the risk of being sued because most patients will simply forgive and forget. In the unlikely event that the patient does file a lawsuit, he's likely to request only a small amount of money because your apology diffuses any anger that he might have. And finally, in the event that the case somehow goes to trial, the jury will be so impressed with your upstanding behavior that they will either side with you or give the patient only a minimal amount of money. That's the thinking. Now, apologists don't guarantee that these benefits will occur in 100% of cases, but not a single one of them occurred in this case. The physician took full responsibility and apologized, but he still got sued. The family received $3 million, which could not have occurred unless their lawsuit demanded at least that much, and it therefore does not appear that the apology had the desired effect on them. And finally, the jury not only sided against the physician, they awarded $3 million, which is 6 times the amount of the average jury award, and suggests that the apology didn't have the desired effect on them either. Now, you might be thinking, well, those are good points, but this is just one case. No, this is not just one case. This is a published opinion, and I should point out that there are currently no published opinions that support the apology theory, so this is what we have. And this case not only reveals multiple flaws in apology theory, it also demonstrates the detrimental impact of apology laws. You see, this apology law that they have in Ohio, and almost all of them are like this, it allowed the jury to hear that the physician accepted responsibility, which made him look guilty, but it prevented them from hearing about his expression of remorse, which might have made him look kind, caring, and decent. This is the worst possible outcome. Statements of sympathy are excluded, statements about responsibility are admitted, and the net effect is that these laws work against physicians. They're some of the most useless laws I've ever seen, and no physician should ever rely upon them. And if you're interested in reading more about this, there's a link at the end of this segment to an article that I had published. It's titled Legal Pitfalls of Medical Apology Laws. Now, how did we ever wind up in this situation? Well, most medical legal experts believe that lawsuits are caused by the following sequence of events. In their minds, this is how it works. First, the physician fails to communicate with the patient about his condition. In an effort to find out what's going on, the patient asks the physician for information, but the physician either ignores the request or responds dishonestly. This causes the patient to become angry, and as a last resort, he files a lawsuit in order to learn what happened. And because this is how they see the world, apologists believe that lawsuits can be prevented by simply telling the patient what happened and apologizing. This will interrupt the cascade of events and no lawsuit will ever be filed. The problem with this theory is that filing a lawsuit is the worst possible way to find an answer. People who are sued shut their mouths, coordinate everything through their lawyer, and release only the minimal amount of information required by law. If it's answers that someone seeks, the best strategy is to do just the opposite and promise to not sue. If you watch any crime-related television show, you'll see that the way they get people to talk is to offer immunity. They promise to not bring legal action. The premise that lawsuits are filed to obtain answers is thus flawed, and the idea that they can be prevented by providing answers is therefore fatally flawed. In the real world, lawsuits are nothing more than a tool used to obtain money. According to the rules of civil procedure, money is the only remedy a court of law can provide. Every malpractice lawsuit demands money, and enough money will make every malpractice lawsuit disappear. Tort reforms that cap the amount of money reduce the number of lawsuits because lawsuits are about money. In simple terms, if a person is not interested in money, there's no legitimate reason to file a malpractice lawsuit. Viewed from this perspective, what happened in this Ohio case is completely predictable. A 49-year-old woman unexpectedly died after elective surgery, and this most likely devastated her family. When the physician admitted fault, they were alerted to the possibility of malpractice, and it became relatively easy for them to seek compensation for their loss. This lawsuit clearly wasn't about finding answers because the family already had the answer. Apology theory rests on the idea that seriously injured people, many of whom face significant financial burdens, would rather have an explanation than a large sum of money. A few people might feel that way, but it's a mistake to think it's a majority. Thanks for listening.